Hi, I'm Philip Hundl. I'm an attorney in Texas. My practice area focuses on representing landowners facing land partition matters or eminent domain or condemnation proceedings. So this video series focuses on land partitions in Texas, and we've gone over some ways in which the parties hopefully can agree on a partition, but if there's not an agreement on a partition, then you're going to have to move to the next option or alternative for you, a co-owner, and that is filing a petition for partition. Now, any type of legal proceeding in court, I strongly recommend that you not go it alone or not attempt to do it as a pro se party. That's always a challenge and a struggle. And you just, in land partitions, I don't typically see parties representing themselves, so they hire attorneys that are very familiar with how land partitions work. So let's talk about if there is no agreement, then what? And the then what is, yes, filing a petition. You're going to need to know all the information about the parties, their addresses, where they can be served, and then the legal description of the property. And then there's some other additional items or things that you can include in the petition. And it's sometimes parties will request and include that in the petition, what particular part and how many acres they would like in the petition. And so if that's something that you can discuss that with your attorney and you can include that or not include that. Also, if you're seeking any offsets or credits or additional value towards your percentage, if you improve the property, for example, built a road or built some other improvement, a building on the property, a barn on the property, and you're seeking that reimbursement, or you're seeking part of the land that includes that barn, then you should ask for that in the petition. So, getting that petition the way you want it from the very beginning is always the best practice. You can amend your pleading once your original petition for partition's filed. Then once you file the petition, obviously it has to, citations have to be requested, and then parties served. Now, if you've already been in contact, hopefully, with the other parties and trying to reach an agreement, and maybe they're already represented by an attorney too, and the attorneys have been trying to facilitate or assist the parties in potentially reaching an agreement, no agreement's been reached, then instead of having to formally go out and get these folks served, the other co-parties or co-tenants, co-owners of the property served, your lawyer can ask their lawyer if they will agree to waive service. So that's something I always ask, and most lawyers are very good about when there's been some dialogue back and forth. It's just a way to save some expenses in the case, because expenses will run up very quickly. And so if there's a way to save a few expenses, always attempt to try to do that. So hopefully that's helpful. Once again, if you're facing a partition matter, please talk to an attorney that is familiar with those type of proceedings, because it's a very specialized area of practice, or it's a very specialized proceeding, I guess I should say. So with that, good luck.